Hello, everyone. Thank you for joining us. Today, we're going to be talking about how to use the H-1B visa to build your workforce. And this is for a specialty occupation that requires a bachelor's degree. And it's a great way for you to get a skilled worker, sometimes right out of grad school or college, and it leads to a green card. So this is a very popular visa. And it takes place only once a year in March. So we're going to let you know what you need to know to be ready to apply in March and to take advantage of this program. Just briefly about me, I founded the Grady Firm in 2012, and we specialize in helping employers with their employment needs, being from employment law to immigration and sponsoring their employees for visas and green cards. And today we are lucky to have Jonathan Durket with us. He is also an immigration attorney at the Grady Firm, and he specializes in business immigration and helps us with our H-2Bs, EB-3s, H-1Bs, O-1s, TN, and perm processing. And welcome, Jonathan.
Yeah, thank you. I'm excited to be here.
Thank you. He always has great things to add. And just a quick disclaimer, this is for informational purposes only. It should not be construed as legal advice, but it's a basic overview, and we'd be happy to go over this in more detail with you. So briefly about the H-1B visas, it is a non-immigrant classification, which means it is not a green card itself, and it helps for three types, and that is looking into visas for a specialty occupation, services of exceptional merit and ability relating to Department of Defense development projects, or for fashion models of distinguished merit or ability. So today we're going to be talking about specialty occupation visas. And what are we going to cover today? We're going to do a lot of information in just an hour or less. And we're going to go over the following topics: what the requirements are for the H-1B visa, how long the period of stay is, what the employer's responsibilities and costs are, as who's going to be paying for this, the employee or the employer, when the employee can start working for the company, how a worker can transfer from one employer to another with their H-1B, how the cap gap works, and this is for people who are in their first year or two after their education. You may have heard of a request for evidence. We're going to talk about that, what that is, and how to successfully respond to one. You may want to be knowing if a spouse and children can come to the U.S. with this H-1B visa. And finally, how and when you can apply for a green card. So Jonathan, why don't you tell us a little bit about the requirements for this visa for the specialty occupation?
Yeah, I'd be happy to. So to qualify for an H-1B visa, the job has to require theoretical and practical application of a body of highly specialized knowledge. Essentially, that means attainment of a bachelor's degree or higher in the specific specialty or its equivalent. And that's the minimum for entry into the occupation into the U.S.
Yes, so this means that you can apply for this with a bachelor's degree, a master's degree, or a PhD, or we'll talk later, you can have a working equivalent, but most of the time, since this is competitive, we would want you to have at least a bachelor's degree. And the bachelor's degree is going to have to match your education. So for example, if you studied aerospace and your work is in aerospace, there has to be a nexus to show that your studies were what's helping you with this job. And so when we are preparing our applications, we have to show that the applicant meets at least one of the following criteria, and that is either that a bachelor's degree is normally the minimum entry requirement for the position, or that it's so common in similar positions, or that it's so complex or unique that it can only be performed by somebody with a bachelor's degree. We can also show that the employer normally requires a bachelor's degree for the position, or that the duties are so specialized and complex that a bachelor's degree is required. And so sometimes when we are researching the job, if perhaps only 80% of employers require a bachelor's degree. We're going to show that this job is so complex and unique that you can only do it if you had a bachelor's degree. So what kind of professions are eligible? We have a pretty extensive list here. Ordinarily, we like to just call it the STEM visa, so science, technology, math, and engineering. But we'll just hold this up here briefly for you to take a look and see if the profession you have in mind is here on our list.
And I think it's important to keep in mind, this isn't an exhaustive list. These are more of the traditional categories that qualify as a specialty occupation, but if you have questions, whether your specific potential position would qualify, feel free to reach out.
Mm-hmm. And years ago, we were successful with somebody in the wine industry. So we were a little bit creative then. That was before it became as competitive as now. But the point is really, you just have to meet the qualifications, and then we show the legal argument to show why you would qualify for the H-1B. And so in terms of education and work history requirements, the beneficiary is the employee who the employer is sponsoring. They must meet one of the following criteria regarding their work or educational history. So number one would be they have a bachelor's degree or higher, and again, the similar subject as the job, and that is going to be from an accredited college or university in the United States. Now, if they had a degree from a university abroad, normally we're going to do what's called an academic credential evaluation, and that is where we hire a professional to evaluate their transcript and ensure that, for example, if you did university in Australia or China, that it's the same equivalent as a US degree, or you hold an unrestricted state license or certification, or you can have expertise in your industry through progressively responsible positions, and that would be 3 years of work experience for every 1 year of a degree program. So if it was a 4-year degree that you're trying to show the equivalent of, you'd have 12 years of progressively responsible positions. And so, Jonathan, why don't you tell us a little bit more about the period of stay?
Perfect. So initial H-1Bs are granted for a period of up to 3 years, and they can be extended for an additional 3 years, totaling 6 years in H-1B status. It's important to note that it can be extended longer for a pending green card when the visa bulletin does not allow for you to file an I-485 because of backlog. So it's a nice perk of having the H-1B visa. You can extend it indefinitely if you're one of those individuals that's impacted by the backlog and you don't have a green card available to you.
Right, and I was just checking online at the visa bulletin, and the current wait for citizens of India is about 11 to 12 years. So often we find that they are the ones that are extending their visa until that green card becomes available. And if you want to check and see where your country is on the visa bulletin, it's updated monthly, and you can check it online at the State Department website. The website is listed below. So I'm sure you have all heard of the annual cap and lottery. As the economy changed and became more competitive, this was something that really has expanded in the last few years. And so the way that this works is there are 85,000 visas total each year that are available for new applicants. And so there's 65,000 available for people with an H-1B, with a bachelor's degree or higher. And then currently, and this could change at any time, but the way that they do this is run everybody through this 65,000 first. And if you have a master's degree from a US university, you would get a second chance at 20,000 more spots. Now, in order to be eligible for the master's cap, you must have a degree from a US institution of higher education. And so just narrowing this down a little bit more, of those 85,000, 1,400 are reserved for H-1B1 visas. We have a treaty with Chile, And we also have one with Singapore that reserves 5,400 visas. So that's taking us down to 58,200 for a bachelor's degree. And so, as we mentioned, if you have a US master's degree, you have a little bit higher chance of being selected since there's another 20,000 master's cap spots. So there's about a 20 to 26% chance of making it through the lottery, depending on how many applicants apply. You can always look online and see every year USCIS announces how many applications it received. And so for last year, it received 483,000 registrations and selected 127,600. So they are selecting more than that 85,000 because people don't always follow through with the application, or it might be rejected for whatever reason. So that is where we have this 26% chance. And so who is exempt from the cap? Majority of people will not be, but if you're an employee of an institution of higher education, or if it's affiliated nonprofit, a nonprofit research organization, or a government research organization, then you could avoid this lottery altogether and apply at any time of the year. And also, if you're doing an H-1B, we call it an H-1B transfer. So if you still have time left on your H-1B visa, so we have a 3-year period, maybe you've used a year and a half, you have a year and a half left, then you can use that and go to a new employer. So although we call it an H-1B transfer, we're really making a new application from that new employer, but you're able to keep your visa cap number, if you will. All right, so Jonathan, we are coming up on the lottery. It's every year in March. Tell us a little bit about how this is going to work.
I'd be happy to. So a couple of years ago, USCIS changed the H-1B system as far as implementing a registration period, as opposed to requiring employers to file complete H-1B petitions. And so under the new system, employers have to register their employees between March 1st and 18th. To register online, it requires a nominal fee of $10 per employee. You have to input pretty basic information about the employee and the position. And then we encourage you to work with us so that we can provide an analysis of the position to determine that, this in fact does qualify for an H-1B visa, so that you don't get selected and then, at a later point realize that, for example, the wage that you want to pay the employee is much too low, or the employee doesn't have a qualifying degree, some of those types of issues.
Right. So we try to, make a spreadsheet of everyone who's applying. We'll review your transcripts, your immigration documents, find out a little bit more about the job. It's better to know ahead of time. I know you can just, easily apply, but then you have to withdraw your application if you found out later that they wouldn't qualify. So this new system is definitely an improvement. Before, we had to prepare the entire application, write out all the filing fees, and then wait and see if you were selected. So this makes it a little bit easier for an employer to try it for more people, see who's selected of the qualified applicants, and then we would go ahead and prepare the application. And so if you don't make the lottery, you can hold out for second or third rounds of the lottery. So the last 2 years, USCIS held additional lotteries in July and in November, and they were giving out more of those spots that were unclaimed. And interestingly, we had two different companies where employees quit in June, just 2 weeks before this additional lottery. So if you're not sure, you might want to hold out a little bit until July to see if that lottery comes through. If you are on OPT, which is optional practical training, and that is after your degree, you can get 1 or 2 years to work for any employer in a similar field as your degree. So you can apply for that extension and then apply again next year. Or if you are abroad or on another status, you can apply again the following year, as many years as you're able to do so. Or you might want to consider another employment-based visa. So some options are non-immigrant visas like the L1 for managers or executives, the O1 for people with extraordinary ability, the TN visa, which is for citizens of Mexico and Canada for professionals, or the E3 for citizens of Australia. And then depending on your timeline, you may consider applying for PERM, but that takes about 1 to 2 years, and it also involves many different steps and many different agencies. So that is something, it's not a quick fix, but it might be a long-term solution. And so if you want to read about these options, we have them all described on our immigration page on our website with links to blogs and videos. And so what is the application timeline? There are very specific dates that we'll need to comply with in order to be a part of this process. And so for the law firms, our job on February 22nd is to begin creating an online registration account on February 22nd. And so we're going to get all the information from our employers. We're going to go ahead and make their account so that we have everything in there ready to go once the registration period opens. So on March 1st until March 18th, we are able to submit those registrations. And so we like to do that early on. But if people decide, over the next 2 or 3 weeks that they actually do want to participate, there's still a little bit more time to go ahead and put in their registration. So registrants should be notified between the 18th and March 31st. So if you are selected, then we would have 90 days to go ahead and prepare that application. The earliest date you can file it is April 1st, and the last date is June 30th. So if you do get selected in the later rounds, then you'd have 90 days from that time to submit your application, but keeping in mind October 1st is the first date that you could work. So you'd want to get that done as quickly as possible so that you can start working and taking advantage of that period. So what are the employer's responsibilities and filing fees? So as this could change at any time, but as of January 2023, here is a great chart that explains all of the filing fees. So everybody will be paying the $10 at the registration period, and then the fees below will depend on the employer. So again, the employer must be paying the filing fees and the attorney's fees. We cannot ask the employee to pay it or have them reimburse the employer or use a third party. And this is in the rules and regulations, and there are penalties if an employer has the employee reimburse them. So as I mentioned, $10 is going to get you into the lottery. And then if you're selected, there is an I-129 filing fee. That's for the petition, and it's $460. There is the fraud prevention and detection fee. That is $500. And then an ACWIA fee. And this is going to depend on the number of employees you have. So if it's 1 to 25 full-time employees, that's $750. And then if you have 26 or more full-time employees in the US, that would be $1,500. Now, premium processing, we ordinarily encourage it because you get a decision within 15 business days. But in the H-1B context, you may not need to use it because we have such a long period of adjudication between the time we file it and starting in October. But say you did get selected later, or there was a reason that you need to know if it's going to be approved, then you might want to use that premium processing and you'll get your answer much sooner. And so for the employers that have 50 more employees in the US, and more than half of them are in H-1B, L-1A, or L-1B status, they're going to have an additional $4,000 fee. And then attorney fees, the employer would pay the firm directly, and that's going to depend on the law firm, where they're located, how much experience they have, and how dedicated and detailed they're going to be. So that's something that you would be interviewing the firm and finding out their fees. So Jonathan, does the employer have to pay transportation for this employee to the job site?
Yeah, great question. So the employer is responsible for transportation for the employee back to their home country if the employer terminates that H-1B employee before the end of their authorized period of stay. If the employee voluntarily resigns, then the employer is not on the hook for paying those transportation costs.
Okay, and so that's going to be reasonable hotel and reasonable flight. And then do you know if there a per diem or meal reimbursement?
I don't know off the top of my head. It's not something that comes up very often. So I'll have to look into that and I can follow up.
Mm-hmm. Yeah, so for other visas, there is a very specific per diem and rules like within the H-2B. But really, once they're here, if you're going to let them go early, then you'll be arranging their transportation home. Okay, so when to apply, we mentioned that it's only once per year. You would apply for the lottery between March 1st and the 18th. We have 90 days to submit the application, and the first date that the employee can work is October 1st. So again, this is an ideal situation for somebody who may be already working for the company on OPT or has another status that you can wait out that period until October 1st. Now, if an employee it's not working out or they are let go, they can apply, or if you're recruiting someone from another company, an employee can apply for an H-1B transfer at any time of the year as long as there's enough time on the visa to make it worth your while. So probably, at least 6 months to a year to make it worth it. Or if they have time, to get an extension, then that would work as well. So you have to submit the application before you start the new job. I know there's always a lot of questions about the details around this. So we would submit the application. And then once we know that USCIS has received the application, then they can start working. And so we like to wait for a receipt notice. Sometimes that can take 1 to 3 weeks, but then you can be more confident that your case has been received. Or if you really need to know if it's going to be approved, you can also do premium processing and pay that extra fee. And then you have that decision and the peace of mind. Otherwise, if for some reason you're not approved, then you would wait and find that out later, and then you'd have to leave the job. So this is definitely a great option when people need to move around and change employers. And so an extension is, as we mentioned, you have the 3 years, and then there's an opportunity for another 3 years. And then later on, if you do have an approved I-140, then you can keep extending it until a green card becomes available. So you'd want to start preparing your extension at least 6 months before your expiration date. And then you would check the processing times online to see how long it's taking to process and if regular processing would be sufficient or if you need to speed that up and use premium processing. Now, amendments, everybody needs to be aware of when we need to have an amendment. So this is anytime there is a material change to the position, like, for example, the company is moving offices or the employee is moving their home office, or now we're switching to a hybrid schedule. So we've done quite a few amendments over the last few years since COVID, where we have people working partially from home, partially from work, or changing any combination of location where they're working. If they change their salary or their job duties, then we're also going to have to file an amendment as well. So the amendment is going to be another I-129 petition. We'll be paying some of the fees, not all of them. And you want to give a little bit of lead time to your law firm so that they can get this prepared before they move. And there are, quite a few different details and posting requirements. So this is a conversation that you want to have as soon as you find out about any of these changes.
Yeah, and to kind of add on to that, I think a best practice is no matter whether you think it's a material change or not, you should certainly reach out because, if it is a material change, even if it doesn't seem like it will be, for example, moving outside of the MSA, then there's new notice requirements that are triggered. Employers want to make sure they're very careful that they file amendments when necessary, even if it can be a bit tedious. So we're here to help with that, and we can analyze whether an amendment really is needed and whether that change that you're contemplating is what USCIS sees as a material change.
And an MSA is a metropolitan statistical area. So for example, if you have an office in San Francisco and you move to another office in San Francisco, that is not going to require an amendment. But if you move from San Francisco to Los Angeles, those are definitely different areas. And so we would need to file an amendment in that case. And so the cap gap is for people with definitely that are on OPT. And so if you are applying in April 1st for the H-1B and your status at school will be ending, say, in the end of May, and then you get 60 days to leave, your status is going to expire by August. So you're going to be out of status. But there is a special provision where you can get the cap gap, and that is going to allow you to stay in the country until your case is adjudicated. So if they're taking until September or October to finish deciding your case, you can stay until that decision is reached. So this is very popular with people on OPT. You do have to make sure that you have maintained your status, otherwise we can't take advantage of this. But this is always something that we end up using every year, and you would want to advise the school about it and get them to give them information, and we'll be having them sign off on that. So we'll briefly talk about a request for evidence. So you may or may not receive one. It's not necessarily an indication of the strength of your case. Sometimes they are random, different periods of time. We've seen more of these depending on different administrations or different policies within USCIS. So it's a request for more documentation. It may be 1 or 2 documents. It may be a little bit more extensive. You'd be getting a letter from USCIS, and they will tell you what kind of documents you need. So we don't recommend just throwing anything under the kitchen sink at them. It needs to be very targeted. It needs to answer what they're asking for and be relevant. We like to provide that as soon as possible, while providing thoughtful responses. And we do find that we usually get approvals pretty quickly after we send those in. So again, don't be concerned or worried if you get one. Sometimes it's just part of the course of the application, but make sure that you don't just send back the same documents that you already sent. Sometimes they do miss documents that we have already provided, so we might point that out in our cover letter, but we always include additional documents as well. Now, you may be wondering if the family of H-1B visa holders can come to the United States with them. And the good news is that they can. A legal spouse may join the H-1B holder, but it must be a legal spouse. So if it is a domestic partnership in another country or a common law marriage, that won't work. They have to be legally married and provide their marriage certificate. Or they can bring their children under the age of 21. So after the age of 21, they would have to be able to come here on their own status. And so whether spouses can work is a little bit more challenging. It's only once an I-140 petition has been approved. So this is definitely not going to be straight away. It's going to take some time for that I-140 to be submitted and adjudicated, and only then can a spouse of an H-1B employee obtain work authorization. Otherwise, they're going to have to go ahead and get their own work authorization status in another way, potentially an employment-based visa for themselves. And so, Jonathan, everybody may want to know how and when can we apply for a green card?
Yeah, this is a kind of a hot topic, and one of the features of being an H-1B visa holder is that you have a significant amount of time in the U.S. to start and complete a green card process. So an EB2 or EB3 category, we call it perm processes, which typically take more than a year. Because of the steps that you have to complete, including testing the U.S. labor market in certain circumstances. While you're in H-1B status, you can have this EB2 or EB3 perm process being completed while you're in H-1B status. It's important for employers to start thinking about this early on in an H-1B holder status because the process does take a number of years. We're here to assist with any questions you have. You won't be able to receive a green card until a green card is available according to the visa bulletin, which is updated each month. We didn't show you an example of the visa bulletin today, but I can tell you that for certain nationals, for example, Indian nationals, the wait is 10 years or more for a green card. Other nationals of other countries might have a much quicker wait, but it's important to start the perm process as early as possible in your H-1B status.
Mm-hmm. And Jonathan, can they sponsor their family members, their spouse, or minor children under the age of 21 through this process?
Yeah, so you're similar to an H-4, which is the dependents of an H-1B holder. Once you file a form I-485, which is a green card petition, it will include your legally married spouse and dependents or children under 21.
Mm-hmm. Great, thank you. Okay, so we do have a few resources online if you want some further reading. We have a whole page about H-1Bs on our website, and it has blogs, videos, overview of the information we provided. We do have a blog that we update frequently with news about immigration and employment options for employers and employees. And then you can sign up for our newsletter online at our website. We send that out at least once a month with the latest updates. And you can always schedule a complimentary 15-minute consultation on our website. We have a scheduling tab. You can go ahead and click there, or we have a more in-depth 30-minute call for a fee where we will provide you with an analysis, pros and cons of the best options for you and how to move forward. And then just a little bit about the firm. We practice in several areas for employers. That would be business advising and contracts, employment advising and all steps of the employment life cycle, immigration for employers and employees, and helping with the practical realities of expansion and location and relocating into the United States. You can follow us on social media or reach out to us at any time. And we would like to thank you for attending our webinar. And now we will go ahead and turn it over to questions and answers.